Hi, everyone, and welcome to another installment of the Access California podcast series. My name is Claire Courtwright. I am the advocacy director at Cal Voices and a primary with Access California. This podcast will be in two parts, and it relates to the United States Supreme Court's decision in the city of Grants Pass and how that relates to behavioral health. So part one, again, will be about this Supreme Court decision and why it is reshaping behavioral health policy and practice in California, and especially at the local level in cities and counties. And then episode two of the podcast will be about local level advocacy in the wake of this Supreme Court decision, which is actually very critical. And it is the mission of Access California to empower people with behavioral health conditions to be involved in advocacy at the local level. So understanding what's going on here is important, and there are opportunities at the local level to do advocacy related to all of this. So first, what the heck is the City of Grants Pass decision? It was a United States Supreme Court decision that's just about exactly 1 year old. And what it did was clear away a rule that was on the West Coast, basically, in West Coast jurisdictions that prevented cities, counties, and states from criminalizing homelessness in a certain way. So it cleared away this protection and it opened the door for new criminalization of homelessness. And how does that relate to mental illness and substance use disorder? Folks with behavioral health conditions are overrepresented in homelessness because they do not have social safety net, meaning there's no source of funding that they can lay claim to be housed when they're unable to work or work to a degree to house themselves. So this directly impacts people with behavioral health disabilities, but actually also directly impacts other populations of disabled people, the elderly, the poor, etc. And so once the Supreme Court cleared away this protection, those criminal pathways, both receiving charges related to being unhoused or being threatened with criminal charges related to being unhoused, that's being used as a tool to move people into court ordered treatment schemas, both through what's called criminal diversion, but also increasingly into civil involuntary treatment schemas. So we're talking about care court, we're talking about assisted outpatient treatment or conservatorships. And all of this impacts not just our community members, but it also impacts the public behavioral health system itself, because these criminal pathways and the civil court ordered treatment schemas suck up a lot of resources in an under-resourced system. And that impacts the ability of folks to have access to services on a voluntary basis. I'll say a little bit more about how that works. And again, how does any of this relate to local level advocacy? Well, again, after this decision in the city of Grants Pass, the types of government that are passing these anti-homelessness laws are actually primarily cities and counties through what are called ordinances. Cities and counties have the ability, just like the state does, to pass laws that affect just their jurisdiction, so just their city, just their county. And it's increasingly the cities and counties that are passing the anti-homeless laws that criminalize acts associated with being unhoused, but also that voting on those laws from your elected officials happens at the local level, city council, county board of supervisors. That is a public process, and one in which you can show up and do advocacy relating to these votes and the consideration of these laws, including getting them repealed. So, what did this decision really say? It's important. So, the city of Grants Pass overturned a protection from a case called Martin v. Boise. And this uniquely affects California because the Martin case offered some protection for unhoused people, but only in the Ninth Circuit jurisdiction. So basically in the Western United States, including California. So under the Martin case, these jurisdictions, these states, and their cities and counties were not allowed to enforce these anti-homelessness laws they were passing, like camping bans, in the event that the number of unhoused people in the locality was greater than the number of shelter beds that were practically available. And obviously, that was a much needed protection. For instance, in the county of Sacramento, there's an estimated 6,000 unhoused people, and there are only 600 shelter beds. So to criminalize folks for camping on public property when there's quite literally nowhere else for them to go is obviously problematic. It's unfair. And it's particularly unfair when those people are disabled, unable to work to a degree to be self-supporting for housing, which in California is nearly impossible for everyone. So the Martin case did offer some protection for our unhoused community members from being criminalized when there was nowhere else for them to go. And also in the backdrop is that there's no social safety net, right? Too many folks cannot even get Social Security, SSI, SSDI, and that is under $1,200 a month. That's not remotely enough to be housed in California and to meet your other basic needs in addition. So this is a catch-22 for members of our community that don't have a way to be housed. And in the Martin case, what was said was that it was cruel and unusual to put criminal penalties on people for doing things they have to do to survive. And that cruel and unusual punishment was prohibited by our constitutional rights under the Eighth Amendment, forbidding cruel and unusual punishment. And the court said essentially, you're turning the status of being unhoused into a criminal act. This is a status crime. This is something that you are making a crime, not because someone has a choice over camping on public property when there's nowhere else for them to go. They don't really have a choice. This is involuntary. And so you're just turning their status as an unhoused person into a type of crime. You can't do that. So that was Martin v. Boise, and that's what the United States Supreme Court overturned in City of Grants Pass a year ago. So to understand the impact, you can just look at what the Supreme Court upheld on behalf of the City of Grants Pass, Oregon. So Grants Pass passed a local ordinance saying that it is a crime to sleep on public sidewalks, streets, or alleyways. It is a crime to camp, which they defined as setting up bedding and or a stove or fire and intending to live there temporarily. It is a crime to camp or park overnight in a city park. If you do any of these things, regardless of the fact that you have nowhere else to go, there is nowhere to go. These are the punishments: steep fines. You get issued a ticket. But when you cannot pay that ticket, it just escalates. The situation auto escalates if you're poor and you can't pay the ticket. So it escalates to more fines because you didn't pay the ticket, and eventually going to jail or getting a warrant for your arrest. For people that repeatedly were cited for camping on public property or sleeping on public sidewalks, they could be subject to a court order telling them to stay off all public property. Well, it's only two kinds of property, public and private. So if you can't be on any public property, where can you be? And so you can get a criminal trespassing charge, 30 days in jail, more fines you can't pay, on and on it snowballs. And so this is what the Supreme Court said was fine, and that cities and counties in the Western United States that previously, if they passed these kinds of laws, weren't allowed to enforce them when there were not enough shelter beds. Now it's free reign. And for legal nerds or aspiring legal nerds, what the Supreme Court said was the cruel and unusual punishments clause only prohibits states and local jurisdictions from punishing you in a way that is cruel and unusual in our history in the United States. And giving people tickets and sending them to jail is not unusual and it's not cruel. So they just sidestepped the real issue. And they basically said there's no limit under the Eighth Amendment on what a local jurisdiction or state can make a crime. So apparently now there's no constitutional protections for us, for all of us, from our states or local jurisdictions deciding that we should go to jail for putting an ice cream cone in our back pocket and walking down the street. It really ripped the lid off criminalization, and it's 100% targeted at a disfavored minority of unhoused people. So how is this decision in the city of Grants Pass affecting people with mental illness or substance use disorder? Again, these disabled people have no entitlements to housing or adequate entitlements to housing under state and federal law. Just a fancy way of saying there's no program in which you have a right to have the state pay to house you or your county pay to house you. And if you cannot house yourself, catch 22. Disabled people who cannot work simply have no way to house themselves, and they have no benefits that are adequate to house them. We do not have shelter beds that are adequate to house people. And there is no place, no property, public or private, that such an unhoused disabled person who cannot house themselves is allowed to sleep. You will die if you do not sleep. Or can't, or quote unquote camp there's no place for them safe to do that where they can't be subject to criminal prosecution for doing it. So this is a huge impact on our community members who are severely disabled, don't have any benefits, don't have anywhere else to go. And it's open season on issuing them tickets that escalate, taking them to jail, etc. Another really incredible, and not in a good way, thing that the Supreme Court said in the city of Grants Pass case is that essentially they endorsed or said it's acceptable and even good to threaten people, unhoused people, with criminal penalties like tickets or jail in order to get them to accept unrelated services, including shelter stays. So this is really highly problematic to have the United States Supreme Court be like, yeah, go ahead, misuse a criminal law. And I'll say a little bit more about why this is so impactful for our community. And, just because someone is committing the quote unquote crime of sleeping under an overpass with a sleeping bag and pillow, how is that crime related to taking Zyprexa? It's not related, right? And so, but you're going to see, and I've already had reports of this from friends and advocates, especially in the East Bay, that cops are going up to people and being like, well, do you want a ticket? You want to go to jail? Or do you want to agree to be in care court? Agree to accept medications to avoid being criminalized for sleeping in public? That is something that legally I have never seen the equivalent of, because what is happening is that person is getting no defense against any of this. To be threatened with criminal prosecution in order to get someone to accept a quote unquote civil outpatient commitment under care court, basically is a workaround. It evades what we call due process, and due process is where there is a court process. You get legal representation. You get to fight what is happening and say, this law doesn't apply to me, or I have a defense I don't want this, and I want the process that helps me avoid it. When they're essentially going completely outside of the court system, completely outside of people's rights, and saying, I'm going to send you to jail unless you accept care court, um, that completely removes, that maneuver completely removes any kind of legal protection for people and their rights. And it's extremely disturbing that the Supreme Court would put its seal of approval on the open misuse of criminal laws. But if you look around California and you read your local newspaper and you listen to what your mayors and your city councils and your boards of supervisors are saying, they are embracing this. They are avoiding the political fallout from criminalizing homelessness when people have nowhere to go, which is not, generally speaking, popular with the public. And they're saying instead, we're not we're not really criminalizing you. We're just giving you a gentle nudge into taking care of yourself through this treatment court. And this is just extraordinarily unfair. People will be railroaded essentially for being impoverished when again that impoverishment is a choice of their state and their city and their county with respect to disabled people. So that's how members of our community are directly impacted by what's happening. And this impact also is on the public behavioral health system itself. So why is that? Our public behavioral health system means our public health plans like Medi-Cal. It means our publicly financed service funding like the Mental Health Services Act, now called Behavioral Health Services Act. It affects the housing programs in the Behavioral Health Services Act. And here's why. There's one system with one pot of money. And when we have more and more people coming into services that are not the time, place, and manner and type of service they're willing to engage in when they're coming in through the court doors, that crowds out and reduces access to services on a voluntary basis. So, what do we mean by that? We mean that if there is a crisis residential program in your county, which is 90-day treatment program on a voluntary basis where you live, 16 beds, and all 16 beds are taken up by folks that are being criminalized for homelessness or brought into care court or AOT through the court system doors, then there is nowhere for a person who is looking to voluntarily engage in services. There's nowhere for them to go. All of the system's resources have been eaten up in various forms of essentially mental health or SUD probation. And there is nowhere for folks who need to access services for their disability to keep them from decompensating and being criminalized. There's nowhere for them to go. So this is really concerning. It also directly increases the mass incarceration of disabled people who are often held illegally in jails in various forms, including under conservatorships without criminal charges, etc. I probably should do a whole podcast on that. Have some guests come. But if you're not aware, you should be aware that we already have extreme disproportionate incarceration of people with mental health disabilities in California. The federal government uses the term serious mental illness. Our systems use this term, and I use the term because it's meant to indicate the folks with a certain range of diagnoses, but also a level of functional impairment. And if you look at that group of people, you're talking about a group of people that's no more than 5% of the general population. But you go into some of these jails, as I have, or worked in some of these jails, as I have, and you're like, holy smokes, 55% of this jail has serious mental illness. 55% of the people in this jail have serious mental illness. So how do you go from being 5% of the general population to being 55% of a jail population? That is extreme disproportionality, and it is not an accident, and it is not because mentally ill people are violent and dangerous and disproportionately commit crimes. It's because they're being criminalized, especially for being unhoused, misdemeanor trespassing, loitering, you name it, sleeping on a city sidewalk. And this is incredibly distressing for the community, including because folks with mental illness are often claimed to be incompetent to stand trial, meaning they're so currently impaired that they're unable to assist in their own defense. And because that case is not allowed to proceed in any fashion, you can't plead guilty, you're innocent. You can't, get out on probation. You can't accept a diversion program until you're competent or until they figure out that we can't ever restore you to competency. So what ends up happening is folks get quote unquote stuck. They get held in jails simply because their case can't proceed because they have a disability and they end up doing excessive time. And inside those jails, what often happens is that folks are placed in segregated units for the mentally ill. Those are single cells and they're locked down in solitary confinement. So anything like local ordinances that increases the criminalization of disability and poverty and the poverty the state chooses to hold people in is devastating for the community. Too many members of our community also die in these jails in horrific ways. So the totality of the picture here after the city of Grants Pass is really bleak. So that's it for episode 1 of this podcast about the city of Grants Pass. In episode 2, we'll talk about local level advocacy, since the primary way that criminalization is happening after the city of Grants Pass is on the local level through city and county ordinances. Thank you so much. Please like, subscribe, and share, and join us for episode 2 of this podcast, where we talk about local level advocacy and city and county ordinances that criminalize homelessness.